Please be seated. We'll hear argument in 21-641, Comcast against Houston Baseball Partners.
May it please the court, Mr. Babcock will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, I am representing McLean Champions and Drayton McLean personally. Today, the court confronts another case where a sophisticated party, represented by counsel and knowledgeable advisors, one with specific expertise in the regional sports network business, attempts to renegotiate through litigation an arm's length transaction, $600 million transaction by crying fraud. I want to discuss two issues. One, why the alleged representations, non-guaranteed projections and predictions regarding an unknowable future, and a supposed statement about who first proposed a Zone 1 rate are not actionable as a matter of law. And the second point being why HBP's alleged justifiable reliance was negated as a matter of law under Grant Thornton and its progeny. I'm going to rely on the briefs with respect to other issues, including standing and the applicability of the TCPA. Point one, we look, as the court instructs us, to the contract language and the totality of the surrounding circumstances. Section 14.6 of the contract has, in its first part, what this court in Italian Cowboy referred to as a pure merger clause or a standard merger clause. But it goes beyond that. And it says, no party shall be liable to the other in any manner with respect to the subject matter of the purchase and sales agreement by any representations except as specifically set forth herein. There is another agreement. Mr. Crane signed an agreement at the beginning of this process which says that McLean Champions and its representatives do not have, quote, any liability from the selection, use, or content of the evaluation material, the due diligence material, and only those representations that are expressly made in a definitive agreement will have any legal effect. Contrary to those agreements.
Excuse me, I hate to interrupt you, but I want to go back to an issue of standing because that's kind of at the front end of this before we get into this. And so in the briefing, we couldn't see that anybody cited Pike. And so, which had to do with, looking at this as really being an issue of capacity. And so my question is that if we look at it that way, how does that affect the propriety of addressing it within the context of the TCPA, which is a different context?
Well, we sought to avoid liability here, and we raised a standing quite clearly. Perhaps it is a matter of capacity. I think standing is a close question, frankly, and particularly in light of the evidence that they've come up with. But the fact of the matter is that the TCPA applies. If there's no standing, then as to HBP, the case is over.
My question is maybe both sides may want to look at that in the context of some post-sub arguments, because that's a question I have, is how the Pike analysis would apply to this issue within the TCPA situation.
Thank you, Your Honor. We will certainly look at that.
The Court of Appeals assumed without deciding that the TCPA applies to this transaction, and I think your argument is also couched in that manner. But if the TCPA does not apply to a legal action brought against a person primarily engaged in the business of selling goods or services, if the statement or conduct arises out of the sale or lease of goods, services, or a commercial transaction in which the intended audience is an actual or potential buyer or customer, why doesn't that sweep in within it the sale of this company to an intended customer?
Yeah, well, because the burden, of course, is on HBP to establish this exception. They did not do so with respect to any of the four elements that are obtained, and they did not satisfy, although they cite the case, and only that case, Castleman, they do not, for example, they don't say, there's no evidence of what McLean Champions was primarily engaged in. What business were they selling goods and services in?
Well, the purchase and sale agreement is part of the record excerpts from it.
I'm sorry.
Isn't the PSA part of the record, parts of it, at least?
Sure, the PSA is, sure. But
So
are they?
doesn't that indicate a sale, a purchase
they
and a
selling-
sale?
But what are the goods and services? Are they that they're primarily involved in? Are they primarily involved in selling tickets, in selling advertising, in selling a baseball franchise? Is that what their primary business is?
This wasn't the operating company, right? I mean,
right.
aren't there subsidiaries that are selling tickets and
That's
that
correct.
sort of thing?
It was
Okay,
not
so do
the
we have
operating
to?
company.
Is there a veil piercing kind of thing where you mix it all together, or do you have to look at it company by company?
I think you have to look at it company by company, and I think Mr. McLean is, there's no record of what he's selling. I mean, we all
Well,
know
there's at least one piece of evidence of what he was selling because we have the purchase and sale agreement.
that there is the purchase and sale agreement, but were the statements, the question is, the purchase and sales agreement a good or a service? And were they primarily involved in that, in selling that good or service?
I also have a question just about, just backing up. You know, the Court of Appeals just assumed that the TCPA would apply, but
Sure.
how does it apply here?
Well, there was a communication on a matter of public concern. And the statute, remember, we're not under the 2019 amendments, we're under the prior statute, and it related to a matter of community well-being. Well, the pleading itself talks about how the Astros fans are going to be affected by what's happened in the sale.
Well, let me ask you, wouldn't that apply to anything having to do, like, say, Kanye West? You know, isn't somebody like that in the same position? Affects public, you know, attitudes
Yeah.
towards someone like that. Isn't that much broader than what this is really meant to apply to?
As this court said in Adams, the statute is very broad. But in addition to community well-being, where the pleading itself, the plaintiff's petition itself, and Mr. Crane's press conference, when he announced the filing of this lawsuit, they say about how this lawsuit and this transaction and these representations, these communications, are going to affect the community at large.
So would your argument be that this would apply to Kanye West also?
I don't want to defend or discuss Kanye West because I don't know
Or
what.
let's say someone, or whomever,
Yeah.
who's in that type of position. I'm not trying to pick on anybody particularly.
Yeah.
I'm just asking about some other celebrity type person that has a huge following within a certain population, or everybody, you know. Would it apply to that situation as well?
Well, there's a recent case that the court denied review on in the Baylor Whiten case versus the Rose Enterprises involving Earl Campbell, and the Court of Appeals did say, yeah, because it's a celebrity, but that it applies. But the Astros are surely a public figure. That's another element of matter of public concern, and that hasn't even been responded to. Not at the trial court level and not in this court.
So you're saying it would apply to every public figure?
Yeah, the statute says that. Statute explicitly says that in 27.013 B, excuse me, explicitly says that any public figure it applies to, yes. And
Doesn't Creative Oil tell us, though, the Creative Oil case, doesn't it tell us that we don't look at whether there is a relationship between the statement and some public interest, but rather it's the statement itself of public interest, or the transaction itself? So here, wouldn't the analogous question be not, do the Astros have millions of fans? Undoubtedly they do, but is the statement about the Zone 1 rate an issue of public concern?
yeah, I hear your question, and I agree with the premise of your question, which is the statements themselves. And you don't have to do relate to a matter of public concern. You don't have to go any further than the petition or Mr. Crane's press conference, which is in the record, a transcript of which, where he said, these statements are going to affect Astros fans and our city of Houston. So they clearly have are a matter of public concern. To me, practicing in this area, this is not one of the closer questions in this case. I think standing is a close question, but I don't think this one is a close question. And you might be tempted to say we can avoid all the thorny questions in this case by remanding this to the Court of Appeals and saying, hey, don't just assume the TCPA applies, decide that case. But Mr. McLean's company, McLean Champions, made an agreement, and the agreement was that they would avoid this very kind of litigation. And things have to come to an end. The agreement was in 2011. Mr. McLean was 75 years old in 2011 and is entitled, as is his company, to have an end to litigation and not to have a matter renegotiated through a lawsuit where a fraud is claimed, where they don't ask for rescission, by the way. They avoid the contract while trying to have it to keep the contract. And as you remember in the Bombardier case, the court looked with skepticism on that. The Section 6 of the letter that Mr. Crane signed said that these representations, only representations expressly made in the definitive agreement, will have any legal effect, and yet this lawsuit attempts to have statements not made in the agreement to have legal effect and for there to be liability contrary to the contract. The question that the six-part test, as Justice Boyd enumerated it in the IBM case, was this a negotiated or a boilerplate? Negotiated, clearly. Did the parties specifically discuss the rates with respect to this matter, the matter that's in dispute? Yes, they did. The record is clear that they discussed it with Gardner and Trawick for the Astros. They discussed it with Littner for Comcast. They discussed it with Greenberg, the investment banker, and importantly, they inserted Section 3.5 into the agreement, and that was an earn-out. And Mr. McLean's company, McLean Champions, agreed to reduce the price by $25 million because of uncertainty about the HRSN. Now, the earn-out was, if the HRSN meets certain financial thresholds, he would get that money back in the future if they met certain guideposts along the way. So there's no question but what the HRSN was something that was known and talked about. Were there representation by counsel? Of course. Was this arm's length? Yes. Were these people knowledgeable in business matters? Well, Mr. Crane had attempted to buy a baseball team before. He was knowledgeable in business. He bought business jets, as we all know. And he had George Postolis as his advisor. A word about Mr. Postolis, a Harvard law grad, who then got the most prestigious judicial clerkship in the state of Texas, and became president of the Houston Rockets, and in that capacity became conceived of the HRSN and brought it to the Astros. The Astros didn't bring it to the Rockets. Postolis brought it to them. He was the manager of the HRSN when the Astros and the Rockets formed it. He negotiated with distributors like Comcast. This is in his affidavit from the 2003 case involving the Fox Sports Net, which is in the record. And he recognized that there is an inherent tension between the teams who are trying to get the highest rate they can and the people carrying the distributors like Comcast who want the lowest rate. Obviously, there is that tension. And that tension existed during the negotiations in 2010 when Comcast sought to become part of the HRSN. And Mr. Postolas certainly knew that based on his experience. And at the end of the day, the parties agreed on a 450 Zone 1 rate. That's the inner city rate for subscribers. Now, interestingly, they claim, HBP claims, that the quote, Astros were told, and this is important, the date, prior to the Comcast closing. So we're now in October of 2010, a year before the closing of this transaction. They were told by somebody at Comcast that, excuse me, that it wouldn't fly or it wasn't reasonable. Well, during negotiations, that may very well be true, although the record is not clear on it. Mr. Pick doesn't confirm what is said of him. But nevertheless, that timing is important because there is inherent tension. But at the end of the day, the 450 rate was the rate that all of the parties agreed on, and that's what they told HBP, and that's what was bought, with the disclaimer I've talked about.
Any other questions? Thank you, Mr. Babcock.
Reserve the rest of my time. Thank you.
We'll hear from the respondent.
May it please the court. Mr. Farrell will present argument for the respondent.
May it please the court. There's a fundamental flaw in the other side's analysis of this case that permeated their position from the trial court to the Court of Appeals and all the way here. They couch this case as one involving pure expressions of opinion. This is not a case about pure expressions of opinion. It is a case about pure expressions of historical existing fact that were demonstrably false, and a case about projections that are intertwined with those false statements of existing fact. That's what this case is about. They ignored that reality in their petition for review. They ignore that reality for the most part in their merits brief in this case, and it is fundamental to understanding the proper resolution of this case. Justice Bland, to your question about the commercial speech exception, clearly the TCPA was never intended to insulate or apply to a seller who artificially induces an inflated purchase price through lies about the business. That's clear. The question is, can we meet here the technical requirements of the exception? The exception does not require that the person involved be the one actually selling the goods and services. It has to be in the business of selling the goods and services. And here, it is clear that both McLean Champions and Drayton McLean were in the business of selling the goods and services by virtue of their ownership and control of the subsidiary that held the franchise. We know that from the record. It's page 1418 and following in the record. That's what's called the Commissioner's Memorandum. This whole deal was conditioned on the Commissioner of Baseball approving the transaction. It's in the record, the Commissioner's Memorandum that says, prior to this transaction, Mr. McLean was the control person of the Astros, and under Major League Baseball regulations had to have and did have the full authority to make all decisions with respect to that entity.
Doesn't Castleman seem to indicate that the goods and services that the person is primarily in the benefit of selling, primarily in the business of selling, have to be the same goods and services that are at issue in the transaction?
I think, contrary to that, I think that was the specific issue in Castleman, but the broader picture in Castleman and from the statute is it applies either to a transaction in the sale of those goods and services or a commercial transaction involving those goods and services. Here, it does not have to be the sale of the actual goods and services. It doesn't have to be a case involving a purchase of a Astros cap or the particular license or service of watching the games on TV. It has to be a commercial transaction, which this undoubtedly was, and it has to involve the goods and services. Clearly, a transaction that changes the ownership of the entity that owns and controls the baseball team involves the goods and services. And we think that's respectfully, that's enough to invoke the commercial speech exception.
So we should look through the corporate structure?
No, I don't think, Justice, it's a matter of looking through the corporate structure. I think it's a matter of applying the literal terms of the statute, which says that the commercial transaction simply has to involve the goods and services. And here, the commercial transaction, which is the sale of the entity that owns the Astros and a concomitant change in the Major League Baseball control person from Mr. McClain to Mr. Crane, clearly involves the transaction, involves the goods and services. And of course, we don't even get there unless the first step is satisfied that the TCPA applies. And on that, I think Creative Oil and Gas, to me, sort of ends the inquiry. It reins in some prior cases about when private communications can be deemed public. And what it basically leaves you with is a private transaction, and here's no question that these two entities on either side were private companies, involving private communications, communications that were held in private. There's no dispute that these were private communications. Everything here was subject to a confidentiality agreement, to the point where 10 years later, documents in this record, they insisted on being sealed because they claimed that 10-year-old financial information still needed to be maintained as secret. The subject matter of the communications, themselves private, the zone rates that a distributor will pay is not a matter of, never communicated to the public, held secret, held confidential, and then at the end of the day, the loss that is being asserted here is the private pecuniary interests of the two parties. My client has sued for its private pecuniary loss from having paid an inflated purchase price. Now, it is true that Mr. Crane said in a press conference soon after the lawsuit was announced that this private transaction could potentially have a collateral impact on the team going forward. Now, he carefully noted in that press conference he wasn't going to allow that to happen because the team would continue to spend the money it needed to progress, which events have indicated has absolutely occurred. But that was a potential collateral effect. That's not what we're suing on here, and it's no different.
Creative Oil involved a private transaction of importance only to the parties to the transaction. And the key distinction here, and tell me whether this distinction matters, but it seems self-evident that this transaction has enormous importance to millions of people in the city of Houston who are concerned about it. It's in the newspaper. Everybody's interested in who owns the Astros and what that's going to mean for the team. And the Oilers left town over ownership disputes, and people care deeply about all of this, unlike a situation like Creative Oil where nobody outside of the deal itself has any particular reason to care. Why wouldn't that matter?
I understand the question, and I think it blurs an important distinction. The question is not whether the Astros and who owns the Astros is a matter of public interest. Unquestionably, it is. The question before the court, though, is are these communications that give rise to the claim a matter of public interest? And they are not. And the parties, both sides, specifically excluded them from being a matter of public interest by insisting that they be conducted under strict confidentiality and secrecy agreements. So the communications were not a matter of public interest. If we take your hypothetical to its logical conclusion, then any action involving the Astros that could potentially affect the team's financial resources, because that then could potentially collaterally impact their ability to hire a free agent in the future, then any cause of action is going to be covered by the TCPA if it involves a sports team or a celebrity or
Do we even need to go that far, though, if the Commissioner of Baseball had to approve the transaction?
I don't think that the requirement that the Commissioner of Baseball approve the transaction imbues the communications that are issued in this case with public importance for purposes of the TCPA. The communications that we're suing on remain, the overall transaction required baseball commissioner approval, but the communications remain private communications communicated privately about a matter that was decidedly not of public knowledge, therefore could not be of public interest.
If we were to agree with the respondents that the TCPA applies, how do you answer that within those confidential communications, there were a number of representations, yet the one that you claim led to fraudulent inducement to enter into the agreement is not included.
I disagree with the premise. Ultimately, the representation that was made here is a representation. There's subsidiary representations that all tie into it, and they're all interrelated to a certain extent. But ultimately, the representation here was that the network has a present value today of $332 million. That representation is embodied in the contract in Section 5.5, which is a representation that the financial statements of the Astros are accurate and have been presented according to GAAP, and that they fairly present the financial condition of the network in all material respects. Then the
And the audited financial statements included a projection of future revenues for a nascent network?
No, it's more direct than that. The audited financial statements, and this is at page 1364 of the record, so the financial statements are themselves attached to the PSA, and at 1364 of the record, the financial statements contain the statement that the fair value today, present fair value of the network interest is $33.15 million, and that this fair value was put into the financial statements by the accountants based on management's information. Management being previously defined in the PSA as Mr. McLean, Ms. Gardner, and Ms. Trewick. And all of those people knew that the interest could not have a present fair value of $332 million if the projections that the rate would be paid in the future didn't come to fruition. And they knew that Comcast, the expert in these networks, had told them these rates will not fly, and these rates are not rates that the market will pay.
So your position is that the disclaimer of reliance can't be effective outside of the representations contained in the agreement if something went into the audited financial statements that ultimately proves to be wrong.
Well, it's more than something going into the audited financial statements. There was a representation, a contractual representation that the audited financial statements were accurate. The audited financial statements say that the fair value is $332 million. And further to your question, though, there is no disclaimer of reliance in this case. There is a standard merger clause, but if you look at it's 14.6 of the PSA, it does not qualify as a disclaimer of reliance under Italian Cowboy, under Forest Oil, and that trilogy of cases along with Swanson. What those cases say is to be a disclaimer of reliance, you've got to be explicit that you're disclaiming reliance.
Well, they referred to a second agreement that says there's no liability from due diligence materials and only representations in writing should have any legal effect. Isn't that similar to Italian Cowboy saying no representations or promises except as expressly set forth herein?
Yes, and that was found not to be an enforceable disclaimer of reliance in Italian Cowboy. And the other reference that I think Your Honor is referring to is in the 2010, December of 2010 initial non-disclosure agreement, which in any case did not, was merged into and did not survive the PSA. But even that document has no disclaimer of reliance. You will find the words reliance nowhere mentioned in any of these documents. And then if you carry forward to the PSA and you look at the indemnity section of the PSA, which is section 13, there are any number of provisions in section 13 that require the McLean side to indemnify the Crane side for fraud. If the transaction disclaimed reliance and made a fraud claim impossible, then there would be no reason for those clauses. Section 13.4D in particular, which starts out as a limitation of remedy section, says no consequential damages for breach of this agreement. It goes on to say that this limitation of liability shall not apply to a lawsuit based on fraud for an inflated purchase price. and I'm paraphrasing slightly, but that's the concept. And that is an express recognition that this very lawsuit is not precluded by any disclaimer of reliance in the agreement because it's specifically contemplated in the agreement.
So the team and the network were sold as a package deal, is that right?
So what was sold was, by McLean Champions, was the ownership interest in a subsidiary entity that itself held the network interest and the Astros franchise.
So there was one transaction in which both the team and the network passed at the same time?
Correct. And
So in the typical fraudulent inducement case, the plaintiff would regret the transaction and seek to undo it because he was induced by fraud to enter into a deal that has now turned out to be regrettable. This is obviously not that. I wouldn't think that this is that. Or,
it's clear.
we have an asset that's worth 3 or 4 times, according to the magazines, what was paid for it. And so, assuming you succeed at this stage of the case and the case moves forward, what is the model for damages here? I mean, rescission would be a classic model, and I suspect Mr. McLean would take rescission right now. How do you recover for being induced to purchase an asset that's now worth many times what you paid for it?
Well, first of all, let me just say for the record, as the court noted, that the current value of the Astros is not a matter in this record. But I take your point. I've read the magazines too. Rescission would be an available remedy for fraudulent inducement. Rescission there's no case that I'm aware of that says rescission is the sole remedy for fraudulent inducement. You can elect to ratify the transaction in the sense of not claiming rescission and sue for damages. And the damages model here is very simple. This network interest was represented to have a value of $332 million, and we say in reality it had a value of 0. Now, if we go forward and try this case, there'll be expert testimony on what the actual value was at the time, but we have prima facie record evidence that it was effectively 0. So the damage model is very simple, the difference in value between what as represented and as delivered.
Would they have sold it to you for 0?
Would they have sold it to us for 0? Presumably not, but they sold it to us on the false representation. When you combine the existing facts and the projections, it ultimately becomes a representation of existing fact or an opinion that under the case law is an exception to the no opinion rule, that it was worth $332 million, and it wasn't. And
It wasn't reflected on their financial statements as worth $332 million.
It was reflected on the Astros financial statements that were represented as being fair and accurate.
Based on a $450 value for their investment in the network, and you're saying that you were unaware that it was based on that future projection, or?
No, we were absolutely aware, and that's why in due diligence we wanted to dig deeper and find out whether that valuation was a valid valuation. And so it was represented to the Astros, or to the Crane Group initially, that valuation came from Comcast, and it reflected Comcast's independent business judgment and expertise based on its running 10 networks across the country, and further, that Comcast had itself bought into the deal based on that valuation. So we said, that's great, but we didn't stop there. We went and said, we want to verify those facts. So we asked the Astros, who came up with the 450 rate, who validated, who endorsed it, whose rate was it? And we were told specifically and definitively it was Comcast's rate. So we said, okay, we're not going to stop there. We're going to go talk to Comcast. We'd like the opportunity to talk to Comcast. And we asked Comcast specifically, whose rate was this? Did you generate it, or did the Astros generate it? Did you validate it? Do you believe in it? And we were told specifically the rate was proposed by Comcast. Comcast had a high degree of confidence that it would succeed, and Comcast had the market power as this behemoth to make it succeed, and Comcast was highly confident that it would happen. Those facts, that was a present statement of fact. I believe, I have endorsed, I have determined that this is a rate. That was false. as subsequently shown by Mr. Pick's testimony. My colleague says Mr. Pick didn't really say
Didn't
that
the
he
very
was-
existence of the most favored nations clause indicate to you that even Comcast thought they were not certain that that was a hedge because they might not be able to ascertain, to get the 450 in the market?
The existence of the most favored nation clause was a relevant fact that caused, in part, the further due diligence of Comcast. And so if Comcast had told us the truth in the further due diligence, they would have said, we don't believe this is a market clearing rate. We don't believe other distributors would pay for it, but we're protected because we have this most favored nation clause. And that would have been really highly relevant information to know. The problem is they told us the opposite. They lied about it. They said, this rate is in here because we have a high degree of confidence that it will be achieved. We believe it to be a market clearing rate. And if you look at those representations and juxtapose them against Mr. Pick's testimony that he gave in the bankruptcy court, it is 180 degrees opposite. Mr. Pick said in the bankruptcy court, Comcast told the Astros that these rates would not clear the market. That was an existing fact, not a promise, an existing fact, and they lied about it.
Was that after the Astros refused to accept lower rates from competitors in connection with building the network?
The testimony from Mr. Pick and Mr. Littner is that they call it a negotiation, but in the so-called negotiation of the rates, the Astros and the Rockets, the two teams came in and insisted on a $4.50 rate and were adamant that there be a $4.50 rate. Comcast then said, we don't believe those rates are market clearing and achievable, and the Astros said, we want them in there anyway. And Comcast ultimately agreed, no question, but then when they were asked about that circumstance later, they told the exact opposite story. And it's material because the Astros, the initial representation to the Crane Group as to why this valuation is real is because Comcast bought in at the same valuation and paid $157 million. That is a great validating fact. But we didn't stop there. We wanted to make sure that Comcast didn't have some other reason to pay higher than the market might suggest. So we asked them, and they lied.
Well, was part of that part of a loan, which ultimately resulted in involuntary bankruptcy? I mean, Comcast is the one that placed the network into bankruptcy because they didn't think that the terms of the loan could be met.
That's accurate.
So there's that countervailing fact.
Well, respectfully, I'm not sure it's countervailing to the specific point that I was making, but to the extent it is, on a TCPA motion where our obligation is to, under the Lipsky case, just to have enough detail so you understand the factual basis of our claim and to have prima facie evidence, countervailing and controverting evidence and or discussions is really not appropriately before the court, I would respectfully suggest. The issue here is not whether we're going to prove our case. The issue is ultimately in front of a jury, or whether the arguments that my colleague make might be great jury arguments, and they might. The question is, have we got enough to survive a TCPA motion, assuming it even applies, and I respectfully suggest that we do.
Any other questions? Thank you, Mr. Farrell.
Thank you.
Mr. Babcock, you have 5 minutes.
Thank you, Your Honor. I would suggest that the court may want to look at Mr. Pick's testimony from the bankruptcy court, which is in the record because it does not support what was attributed to him. The fact of the matter is that Comcast did endorse the 450 rate because they agreed to it when they entered the network. Not only did they agree to it, but they paid it once the network launched, and Comcast had almost half of the market, the Zone 1 market. So there's not a question of how they didn't endorse it. Of course they did. And of course in the negotiations leading up to the agreement, there was, as Mr. Pick did say, a difference of opinion as to what rate was appropriate. But that's all opinion looking forward as to what may or may not happen. Justice Bland, you asked questions about the audit numbers. It's quite clear that the audit number, which valued the network It doesn't mention 450, it doesn't mention Zone 1, it doesn't mention rates. What it mentions is what Comcast paid for their share of the network, and then it did the math. And that's what came up with it, and HPP certainly knew that. And if it was so important to put this into the this zone rate thing, and that they did so much due diligence on, then why in the world wasn't it in the agreement? You can look at the agreement. There's nothing about a zone rate. There's nothing about 450. There's nothing about that aspect of the matter. Justice Blacklock asked about how millions of people care deeply about this. And it's true, and the premise of your question is accurate, and the complaint, the petition here says, quote, there were many other victims of defendant's scheme, talking about our supposed scheme, and they were the fans of the Astros. So this clearly had was a matter of public concern. Justice Bland said there were a number of reps that were not included, and the response was, oh yes, relating to the supposed audited financial situation, but there is nothing in the agreement about the rates or about 450. Justice Blacklock, you're correct. The team in HRSN was sold as a package. And Justice Huddle, the most favored nations clause, it wasn't just us that could have figured that out. That's a red flag. It's a classic red flag. It's probably the biggest red flag there was, because HPP has got to know that if, as they were told by Mr. Littner, that this might not clear, we don't know, we just don't know. Mr. Littner pointed out, and it's in the record, without contradiction, that Portland didn't clear at all. And he said, you got to be aware of that, it may not clear. But if it doesn't clear, half the market, and it goes at a lower rate, half the market is going to go with it, because Comcast has the most favored nations clause. And Mr. Pistola certainly knew that, having negotiated these carriage deals for this very network. The Creative Oil and Gas case, unless the court just wants to hold that Creative Oil and Gas creates a judicial exception to the TCPA, such that if there's any business transaction, B2B transaction, then the TCPA doesn't apply. I don't think that was the holding in Creative Oil. And as was pointed out, this was a purely private thing. It strikes me as odd that if this transaction was so purely private, that the day the lawsuit is filed, there would be a press conference held by HPP. Clearly, it was not the type of Creative Oil transaction that was contemplated by the holding in that case. I have 25 seconds left, but I'll give it back to you unless you have some more questions.
Any other questions? Thank you, Mr. Babcock.
Thank you, Your Honor.
Case
And
is,
Your Honors.
case is submitted. That concludes the arguments in the cases set for this morning. The marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.